All right, ladies and gentlemen, once again, I'm Professor Brenton Boyce, and I'm lecturing on Chapter 7 from our textbook, Winning Courtroom Testimony for Law Enforcement Officers, the Law, Art, and Science of Effective Court Communication by Matthew J. Medina. This class is Courtroom Testimony, CRJS260. So let's go ahead and jump into it. Chapter 7 is nothing more than a closure of the first section of the textbook, and it's called A Few Rules for the Road. Just a brief review of everything we learned about in the first chapter. So, chapter 1, we just talked about the basics, the anatomy of a trial. So, before we can go into everything, we're going to talk about, well, how does a trial go from top to bottom of a trial? From the selection of a jury, opening statements, all the way to the end where we talk about jury deliberations and verdicts. So that's what we talked about in Chapter 1. Chapter 2, we talked about prosecution witnesses, why they're called, why truth-telling is so important. Talked about defense direct examination of police officers and other things. Chapter 3, we talked about what to do before court, the importance of preparation, of course, as a law enforcement officer, the book is about preparing law enforcement officers, but the way I teach it for anyone that may be going to court to testify. Whether you be a forensic person or an expert or officer or a lay person, a regular person that saw something and now you're being asked to come to court by the defense or the prosecution. Either way it goes, these rules apply. So it talked about court preparation. Then chapter 4 was about persuasion, not how the witness persuades, but how the witness is used in the persuasion that the litigant must do. So the litigant is essentially using the witness as an ingredient to their cake, or a layer. And it's the litigant's job to now persuade, but they use witnesses to tell the story. We talked about that in chapter 4. Chapter 5, we talked about courtroom demeanor and body language, how the evidence or the testimony is not just what comes out of your mouth, but is you, how you're perceived, how your body language, how you're dressed. All that can go to your credibility. You could be given 100% truthful testimony, but if it's coming out of your mouth and the jury doesn't believe you because of how you look, it's all for naught, right? So body language, all that stuff's important. Then chapter 6, we talked about eyewitness testimony, the importance of it, about details, about how whether or not you accurately perceive what you're testifying about, whether you actually remember it well, and then also whether you can talk about it in an effective way. And now we're talking about chapter 7, a few rules for the road, where we're kind of tying it all together. Chapter 7, of course, a few rules for the road. Of course, in the book, they just, pretty much talk, there's a few questions. The prosecutor's cases consist of one thing: admissible evidence. What is admissible evidence? There are two general categories of evidence. These include physical evidence and testimonial evidence. But as I told you before, no physical evidence gets in without being testified to. So pretty much all evidence is testimonial evidence. Even physical evidence has to be testified to. So physical evidence is anything tangible, even documents or stuff like that. The murder weapon or the email, the copy of the email that was sent to show that this person did this or had this motive. It can include things such as clothing, weapons, blood, bullet fragment, stolen property, handprints, etc. Testimonial evidence, on the other hand, is witness or defendant testimony or statements. So it's nothing more than statements that are being made. So it's you saying what you saw, as opposed to you saying that this is something connected to the case and this is how. So like I said, either way it goes, even physical evidence has to be testified to before it gets in. So chapter 7, there were a couple questions they asked, just some questions where they talked about objections. We're not going to go through that, but we are going to go through like the review. Chapter 7, in a few rules for the road, it says testify only about those matters of which you have personal knowledge. You can't testify to what someone else said. Now we're going to talk about that later on. It's called why it's not admissible. It's called hearsay. but you can only testify to what you perceived. The court and the jury can't make decisions um, um, on something that on testimony that you didn't perceive. So you say, well, Johnny saw it. Well, if you're saying what Johnny saw, where's Johnny at to testify to what he saw? He needs to be here. You can't talk about what other people perceived or how other people felt. Now, you can talk about how other people looked and how they were acting, and we can draw the conclusion, and that's circumstantial, but we can draw the conclusion as to how they felt based upon how they were acting. So, a question that says, well, was Johnny sad? Of course, the opposing party would probably get up and say, objection, Your Honor, that is speculative. He can't testify as to how someone else felt. Only they can testify to that. But what you can testify to, rather than the litigant asking the question, how did Johnny feel, you can ask the question, did you see Johnny that day? How was he acting? He was crying. What was he crying about? I mean, did he tell you what he was crying about? Or, so just that he was crying or he seemed sad, that's not a testimony about how he felt, but that's a testimony about how what you perceived and how he was acting. And you can draw the conclusion that he was sad about something because of how he was acting. So there's a difference. And there's a difference between saying how did he feel and how did he act. So you see the difference. Small difference, but it is a difference. Argumentative question is really an argument disguised as a question. Of course, that's from the litigant side. So a lot of the stuff in Chapter 7 is about the type of questions you may get. An ask and answer question is a question that the questioner has already asked you, and you guessed it, you have already given him or her the answer. So these are things that can be objected to. Objection, Your Honor, asked and answered. Of course, the main purpose of a trial is to get the truth out there and get the jury the best knowledge possible, and also be efficient. So we don't want to be redundant. And the court is not going to let you be redundant and keep asking questions over and over again, because you'll be in that trial for days. So that is an objection where you say where the litigant stands up and says, Your Honor, objection, this question has already been asked and answered. Always give the prosecutor or the questioner a second or two to object before answering a question from the opposing party. So if the opposing litigant is cross-examining you and they ask you a question, it's always best to pause, let the question soak in and then answer it. So you want to let the question soak in so you can kind of process your answer and think, but it also gives the lawyer that's calling you time to think and kind of run through their head whether or not that question itself is objectionable based upon the rules of evidence. So we're going to learn some rules of evidence, a few of them, but not going to them in depth. But so in trials, attorneys will object to questions, and that's based upon the rules of evidence. You hear me talk about hearsay, relevance, asked and answered, and stuff like that. So you'll hear me talk about those. Now we're going to learn about hearsay, and I'll mention relevance as well. But relevance generally, I'll give you the relevance rule now. That's any testimony is relevant if it tends to prove or disprove an essential element in the case that needs to be proven in the case to prove guilt or innocence. So if it's a murder case and litigant asks, well, what was the score of the basketball game that night? The opposing counsel is probably going to stand up and say, objection, Your Honor, what is the relevance? Now, it's kind of up to the judge at that point, but, the opposing party, the party that asked the question can say, well, Your Honor, it was relevant because this witness is testifying that they were at the bar watching the game when they say they perceived the murder. If they were there watching the game, they should know the score. Stuff like that. Now, whether or not it's going to be relevant, it's going to be up in the air. Probably not going to be relevant. The judge is probably going to sustain the objection because it probably isn't relevant. But that's you'll see questions be objected to. So that's what happens all the time. So when you're being asked a question, brief pause, let it sink in before you answer, just to make sure you getting it correct. You understand the question, and then you answer it. But it also gives the litigants time to possibly object to the form of the question or to the question itself, because it may not line up with the rules of evidence. So the rules of evidence, we just talked about it. The rules of evidence are the rules of the road for trial. So we call them the rules of the road for trial. So what's admissible and what isn't. The forms of questioning. We're not going to go through all that because this isn't the evidence class where I'm teaching you guys how to litigate. I'm teaching you guys how to be effective courtroom testifiers or communicators. So you're going to learn some of the rules of evidence to understand, how you need to be answering questions of what you can and can't say. But we're not going to go through we're not going to go through the types of questions that are allowed and aren't allowed. A few of them, but not a whole lot. That's not necessarily the purpose of this class. So a question is based upon a proper foundation when it includes information that helps you to determine the specific matter upon which the questioner wants you to comment. Questioners often slip improper commentary into their questions. It happens. And that's kind of a trial tactic. As a testifier or a witness at trial, that's kind of none of your business. But it's something you may not notice. But as attorneys and litigants, we're always trying to kind of skirt the rules and get something in. Even with our questions, right? So it may be stuff you don't even notice as a person on the stand testifying, but litigants, we're trial attorneys are very slick at trying to get our point out, right? Because the one thing about it, even once a judge rules on an objection, if the question and the answer if the answer to the question has already come out, even when the judge says, "Ladies and gentlemen of the jury, please disregard that answer and that question," at the end of the day, can you really unhear it? Just like you can't unsee something, right? You can't unhear it either. So now the attorney may not be able to go back to that answer later on, but it is what it is. You've already heard it. And sometimes, the innuendo, everything they need is already there to either create reasonable doubt or to stomp reasonable doubt out. So you can't unhear it. So the litigants, we have little ways we try to slide stuff in. It's just what's going to happen. Let me see. Questions that require you to explain what someone else was thinking are improper. And I talked about that before. You can only talk about what you perceived and how you felt. Otherwise, it's hearsay. And we'll talk about what hearsay is later. So, those are a few rules for the road for Chapter 7. In the next section, Section 2, we move on to Chapter 8, and we start talking about direct examination, or the types of questions or the rules that apply to direct examination. But for right now, that's it. And even with Chapter 7, there is a little there review questions, and like I said, you turn the book upside down and you get the answers to those review questions, so you can kind of challenge yourself. But if you do that, you're going to be prepared for quizzes and even possibly the final exam in this class. So if you read and then read the chapters and do the review questions, you're going to be more than prepared to do well in this class. So without further ado, you guys take care. I'll see you again when we talk about Chapter 8. All right, bye-bye.